A very quick round of introduction. If all of you could just speak your name and the state from which you've come. We would start with Dhairya Patil, please. Yeah. You just have to switch on your mic, and after you speak, you can switch off the mic here. You just have to touch that silver button, that silver.
I am Advocate Dhairya Patil from Maharashtra. And I've been practicing in different sessions courts as well as High Court of Bombay and even at the bench at the Aurangabad bench. I was chairman of the Bar Council of India for a few years and member of the Bar Council of India and Bar Council of Maharashtra and Goa for almost 19 years. I've been associating myself with Collins Group for the last 15 years or so, attending various workshops, and I'm very glad that I was invited for today's workshop. Thank you.
Hello, good morning everyone. I'm Suresh Kumar, I'm an advocate from Hyderabad. I belong to Andhra Pradesh Civil Liberties Committee. That's it.
Good morning everybody. I am V.M. Krishna Reddy from Hyderabad, practicing advocate. I am also a member of the Human Rights Forum, Andhra Pradesh. Thank you.
Good morning, everybody. I am Advocate Anil Aikera from Ernakulam, Kerala, practicing for the last 10 years. That's all.
Good morning, everybody. Good morning, everybody. I am Narayan Samal from Orissa. I am at present Vice President of All Orissa Lawyers Association. I am having practice in criminal courts and also I am a social worker. I am very glad that I have been invited to participate in such August discussion body.
Good morning, everybody. I am Tanveer Ahmed Siddiqui. I am an advocate practicing in UP courts. I am also associated with the Human Rights Law Network.
Good morning, everybody. I am Tejinder Singh from Punjab and Haryana High Court, Chandigarh. I belong to Lawyers for Human Rights International Human Rights Organization.
I am Navkiran Singh. I am a practicing lawyer in the Punjab Haryana High Court since last 20 years. I am General Secretary of Lawyers for Human Rights International, which is a body having its roots mainly in Punjab, but we have other associates in the whole of country. So it's a great honor to be present over here. Thank you so much.
Good morning, everybody. Myself, Gagan Agarwal, advocate, General Secretary, Lawyers for Human Rights, Chandigarh Unit. I am practicing in criminal and civil or in all fields. Thank you, everybody.
A very good morning to everybody. I am Yadvinder Singh Tillon, a practicing advocate in Chandigarh and also associated with Lawyers for Human Rights International. And I visited various workshops and visited various other courts from the organization. And it's a great pleasure to be here and to have a chance to listen to everybody.
Good morning, everybody. My name is Anjuman Ara Begum. I am from Northeast Network. I am coming from Guwahati, Assam. Thank you.
Good morning, everybody. I am Advocate Vijay Hiremat from Bombay. I work with HRLN and I look after the Criminal Justice Initiative.
Good morning, everyone. I'm Geeta, Advocate from Chennai. I'm also associated with Human Rights Law Network, heading the Human Rights Law Network chapter at Tamil Nadu. Thank you.
Good morning, everybody. I am Zach Yaqub of the Constitutional Court of South Africa. I have been a friend of HRLN because we have the same objectives and views, more or less, but we've been friends now for about 6 years. Thanks.
Good morning, everybody. I'm Anu Yaqub, and I'm his wife.
Good morning, everybody. I am Faisal Qadri, advocate from Srinagar, and I work with HRLN Kashmir unit.
Good morning, everybody. My name is A.R. Hanjura. Basically, I'm a practicing lawyer and I'm a social activist associated with different social organizations in Kashmir. Thank you.
Good morning to everybody. I'm Professor Afzal Qadri. I have been the Dean and the Head of the Faculty of Law, University of Kashmir, and I have been teaching in the University of Kashmir since last 30 years. And my field of specialization, of course, is police, criminal law, and criminal justice administration.
Good morning. I am Irfan Noor from the Kashmir High Court Bar Association. We have been dealing with the human rights throughout our as a political movement and as well as through the law and the justice system.
I am M.N. Patnaik from Bhubaneswar, a retired district judge. Thank you.
K. Balagopal from Hyderabad, General Secretary of the Human Rights Forum, Andhra Pradesh.
Good morning. My name is Kiriti Roy. I am from West Bengal. I am representing our organization called Mashum. Thank you.
Thank you, everybody. I am Mongol Debarma from Tripura. I am practicing lawyer, Guwahati High Court, Agartala Bench.
Good morning, everybody. I am from Manipur. My name is Kaide Mani, advocate, practicing for the last about 30 years. And I am the former president of All Manipur Bar Association. And basically, I am a human rights activist. Thank you.
I am Mehum Rakis, a practicing advocate, and now I am working with the Human Rights Law Network Manipur unit.
Good morning to all. I'm Jolin Furelapin from Manipur. I'm a practicing advocate too. But it seems like I'm the odd man out in this group because back at home, I've been defending the police persons who have shot down innocent people there. And that's it.
Good morning, everybody. I am Sankar Subbu, advocate from Chennai. I'm practicing in criminal side over 27 years, and I am a human rights activist.
Good morning, ladies and gentlemen. I am the oddball in the group. Even though I studied law and I was a pro-vice chancellor of the National Law University in Jodhpur. Basically, I am a scientist, forensic scientist. I was the principal scientific investigator in the Rajiv Gandhi assassination case. Now I am crusading against the so-called truth-detecting techniques, including narco-analysis, which I call the terrorism of today.
Good morning. My name is Preeti Verma and I work with Human Rights Law Network in New Delhi.
Good morning. My name is Josh Gammon. I'm from the United States. I work with HRLN, and it's a pleasure and a privilege to be here.
Good morning, ladies and gentlemen. I am Advocate P.K. Ibrahim, practicing lawyer in the High Court of Kerala. I am also the President of Human Rights Defense Forum, Kerala. Thank you.
Good morning, everybody. I am D.B. Binu, advocate from Kerala. I am the editor of legal journal, Niyama Samiksha, and an associate with the Human Rights Defense Forum, Kerala.
I am from Kerala. My name is M.B. Krishnan Nair. I am president of the Advocate Bar Association. I am also General Secretary of Law Society of India. I am practicing in Kerala as well as in Delhi, in Supreme Court also. And I am representing various other associations in which I am president or secretary. And the human rights activities, I am an activist, and I am also helping all these downtrodden persons for getting the human rights activities benefits. Thank you.
Good morning, ladies and gentlemen. I am Abdul Salam, an advocate from the Kerala High Court. I was groundbreaker in the High Court and also senior standing counsel CBI in the High Court. I am now the Vice President of People's Council for Social Justice and Organization of Justice V.R. Krishnaya. I also served as Special Prosecutor, Anti-Corruption Unit, CBI New Delhi, and also President secretaries in various organizations, human rights activities. I am very much interested and involved. Thank you.
Colin Gonsalves, Human Rights Law Network, a lawyer practicing now in Delhi. I used to be from Bombay for many years, moved to Delhi in 2001, and active on all kinds of litigation. Good morning, everybody. And it's such a distinguished gathering, such an exciting gathering of people. And thank you for coming to Delhi at a time when it is so hot here, particularly those of you who've come from Kashmir and places like that. Professor Qadri was saying that we should have had this meeting in Gulbarg, so maybe the next meeting Professor Qadri will organize there. A few introductory remarks before we start, because we are starting quite late. There's some more friends coming in, but we'll introduce as they come. Oh, we are happy to have with us KG Kannabaran, the president of PUCL, and a distinguished advocate from Andhra Pradesh. We'll take a quick round of the introductions for the persons who've come in, starting with KK Rai. Rai Saab, just introduce yourself, please, and then we'll take... Sir, a quick introduction, sir. Rai Saab, please come up. Come up. There's space here. There's space up here as well. Shakil and your friends, just introduce
Shakil,
yourself.
advocate from Hyderabad, working for Human Rights Law Network. Thank you.
And next to you? Bangalore. Welcome. And Kanna, please, if you don't mind.
President PUC.
Yeah. Welcome, Kanna.
I'm R.K. Mastri, advocate from Allahabad High Court.
And Mahesh, please come. Despite the agitation you've reached, I see, come. Yeah. Just introduce yourself, Dave.
Mahesh Voda from Jodhpur, advocate.
Practicing on the criminal side for many, many years. Welcome once again, and let me make a few introductory remarks before we start with the first session. We conceived of this meeting over about a year when we saw these Supreme Court cases coming one after the other, dismantling the criminal law protection of accused persons. There are 2 or 3 justices in the Supreme Court who are particularly active on the criminal law bench, completely doing away with the precedent of the last 30 to 40 years. In the Malimat Committee, there is a passing reference to judges coming up to the Supreme Court without a criminal law practice and learning criminal law once they reach the Supreme Court. I think perhaps that will be the only worthwhile observation in the Malimat Committee report. And he says, the Malimat report says, we don't want judges to become apprentices of criminal law when they reach the Supreme Court. We want people with a long criminal law record to come to the Supreme Court and use their criminal law background to develop the law in the country. Like I said, that is possibly the only rational and good observation in the Malimat Committee report. But we saw that, and there was widespread unhappiness in the country over the way in which criminal law was being dealt with by judges who had never dealt with criminal law, and the whole agenda changed. And we saw a perceptible shift from the protection of the rights of the accused persons to an overwhelming preoccupation with the pushing up of the rate of conviction at any cost. There was, of course, the preoccupation also with the delays in the criminal justice system. But the government and the Supreme Court reacted to that in its typical fashion, not by looking at the root cause of the problem, but by introducing fast-track courts and other ways of doing away with criminal justice protection and coming to a quick and hasty conclusion in criminal trials. You will hear first of all from Dhairyashil Patil from Maharashtra how the Supreme Court has actually diluted the criminal law protection of the accused over the past few years. That will be the first session, and we'll have a discussion after that. I want to say that this is not going to be a session where there will be long speeches. The introductory speeches go to half an hour, but normally the interventions are for 10 minutes on the panel. And we would encourage, since there are so many people who are senior in the criminal law field, we would encourage all of you to speak up as often as you like and intervene as many times as you like. And if the session goes a bit beyond schedule, that's quite all right. As far as the Malimat Committee report is concerned, we were told when we took up the campaign against the Malimat Committee that we ought not to do it because the committee report has been shelved. Nothing could be further from the truth. The Malimat Committee crops up again and again and again. I was in the Symbiosis Law College in Pune about 3 months ago, and there were 4 justices of the Supreme Court there, and they were speaking to the students. And every single judge made it a point to tell the students that the Malimat Committee ought to be implemented. And I got a chance to speak at the fag end of the meeting after the justices had left, thank God, and I was able to say things quite frankly to the students about the Malimat Committee report. But it is very much on the agenda, and you will see shades of that, shades of the recommendations of the Malimat Committee in the Criminal Law Amendment Act 2005 and the Criminal Law Amendment Bill 2006. The Malimat Committee, as you know, and we'll have 3 persons speaking on this, and then there will be discussion, seeks to undermine every principle of criminal law jurisprudence. Beyond reasonable doubt, Malimat says, I don't agree with this. It should be abolished in India. And as long as the judge is convinced that it is true, the judge can convict. What on earth does that mean? The right to remain silent, he wants abolished. And he's recommending a procedure by which the defense will put in its defense statement. And then, like interrogatories on the civil side, you will ask the accused person to clarify certain parts of his defense. And then the trial will begin. And of course, confessions to a police officer. All of us remember Justice Ramaswamy's very sterling dissent, strident dissent in Kartar Singh's case, where he spoke out against TADA, the TADA provision which made admissible in evidence confessions to a police officer. This is what Malimat recommends. This is just the tip of the iceberg, but you'll hear and we will discuss quite a bit about Malimat because Malimat is lurking in the shadows like an evil monster waiting to surface and reassert itself. So Malimat was discredited when people like Upendra Bakshi and others in the country spoke out against Malimat. They were taken aback to see civil society response, but Malimat is very much on the agenda again. You will also discuss in today's session the criminal law amendments, both the Amendment Act of 2005 and the Bill of 2006. You have seen how middle-class society, particularly in Delhi, has spoken out so vehemently for the punishment of hostile witnesses. And many judges have commented that hostile witnesses should be severely punished. No comment on the conduct of the police, no comment on the way in which they conduct investigations, no comment on how the poor in India have lost faith completely in the police. Not a word on torture in the Malimat report. Not a word on corruption in the Malimat report. Catch this poor witness who's intimidated possibly by the police itself. Catch this poor witness and put him in jail for changing his statement. Narco analysis, my senior colleague here has spoken about terrorism in the form of narco analysis tests and so on and so forth. We have seen media trial in case after case and details of narco analysis being told to the so-called details of the narco analysis test being told to the public in case after case. Police reform, we have been confronted by one Mr. Prakash Singh, formerly a senior police officer who went to the Supreme Court, and the Supreme Court passed certain orders in his case. People are fascinated by the decision, the first order of the Supreme Court. People are fascinated by Prakash Singh and what he has to say. But we know Mr. Prakash Singh personally, and we know him very well. He came for our Manipur meeting, where after victim spoke of how the police had tortured and killed people in Manipur, Prakash Singh came to the dais and said, "I'm a nationalist. If there be rivers of blood, so be it." This is Prakash Singh, who is now promoting police reform in the country. And you have the viewpoint of the Commonwealth Human Rights Initiative also, which we will circulate here today. We'll give you copies of their point of view. We disagree very strongly with one of the main groups that is promoting police reform in this country, and that is the reason we want senior criminal lawyers to look at what is being said, first by Prakash Singh, a police officer, and second by the Commonwealth Human Rights Initiative. We have also circulated a copy of the Jeevan Reddy report, which created huge confusion in Manipur and Delhi and other parts of the country, where Jeevan Reddy, a judge of the Supreme Court, was commissioned by government to comment on what should be done to AFSPA. And he suggested that AFSPA be repealed and the substantive parts of AFSPA be introduced by way of amendment in the Unlawful Activities Act. So in effect, what he was saying was not the repeal of the act, but the change of the name. But because in one paragraph, he said AFSPA should be repealed, many didn't read the subsequent paragraphs which said that the provisions of AFSPA should be put into the Unlawful Activities Prevention Act and made applicable for the whole country. Many senior human rights activists in Manipur and in Delhi and other places said we support the Jeevan Reddy report. And there was a push from the Home Ministry to get human rights activists and lawyers to ask the government to implement the Jeevan Reddy report. A move that we sabotaged quite adroitly, but it created huge confusion in the minds of human rights activists and lawyers in the country. So that we have also circulated, and you will find it with you. My friends, ladies and gentlemen, there is tremendous confusion in civil society as to the way in which criminal justice is being reformed. Many, many well-meaning persons are very confused by all the things that they see on television and in the newspapers. Like I mentioned, the punishment of hostile witnesses and so on and so forth. And there is a great deal of confusion even in the ranks of the civil liberties movement. And we thought that this meeting would be an important first step where we pool together the intellectual resources that we have amongst us by getting people for this meeting, and perhaps to have a campaign on criminal justice reform which will make a break from the kind of very ordinary and commonplace and wrong stuff and information and ideas that you see floating around. So without any further delay, we'll start, but let me make 2 or 3 points. One is that, as I said, we will have very short interventions, followed by discussion. When you speak, if you don't mind, please say your name, because the camera will catch what you say and will catch your name as well. Please don't be distracted by the cameras. The reason why we have this is because we intend to produce a training module for activists and lawyers throughout the country, and we'll circulate that throughout the country on criminal justice reform. So many of the observations and the remarks that you make will be caught on camera and turned into a module, a training module for persons. So before you speak, please put on your mic. It's got a silver patch which you will press and it'll come on. And then make your intervention. But give us your name, and don't mind if you have to give it again and again and again, because the camera will catch you. Right, that's all for now. Thank you very much. And I'll call upon Dhairashil Patil now to make the first presentation.
Good morning, everybody, and I would request on behalf of the organizers to put off your mobiles, please. There should be no intervention by the mobile. The task that has been assigned to me is to refer to certain recent judgments of the Supreme Court in which there has been a marked change of attitude from the apex court, even on settled principles of criminal justice, which were settled during the last 30 or 40 or even 50 years. And therefore I have collected certain examples of the recent pronouncements of the apex court. But before I go straight away to those pronouncements, I would make a preliminary observation. As Colin rightly said, during the last few years, there has been a sort of wrongly informed middle-class reactions, which you find in the media, in the television, in the print media, that there have been increase in number of acquittals, witnesses are turning hostile, there have been increasing number of cases of violence against women, and so on and so forth. As a response to this, the politicians, famous for their knee-jerk reactions and always trying to be on the right side of the public sentiment, the so-called public sentiment, have introduced a number of draconian laws during the last few years. You call them by different names. It may be coffee posa, it may be pota, it may be mocha, it may be tada, but the sum and substance of these potas and others is to give a sota in the hands of the police machinery so that they could misuse it. And there have been umpteen number of cases recently reported of custodial violence. And the so-called heroes of the middle class, like KPS Gill, Seshan, Mrs. Bedi, Pradeep Sawant, Daya Nayak, are falling by the wayside because of the exposure which has exposed these people and their so-called heroics. But there has been a number of reasons behind this. The politicians and the media are concentrating on the so-called terrorism without going into the root cause of the so-called terrorism. They are not going into the root cause of violence against women. And therefore, what we find is there is a clamor for punishing hostile witnesses. There is a clamor for more convictions. And not a single conference goes without the judge or whoever presides over it saying that it is unfortunate. It starts with an observation from the apex court judge that it is very unfortunate that there are almost 80% or 90% acquittals in this country. And this rate has to change. And therefore, there is an inverted logic by which these gentlemen, instead of presumption of innocence, are putting forth a theory of assumption of guilt on the part of accused. Therefore, people like us have to come together and put our brains together and try to find out as to what could be done about this. Now, as you know, that in our criminal law, as Colin rightly said, that there have been certain basic tenets, basic principles, like presumption of innocence, benefit of doubt, the inherent distrust in the police machinery which is available in this country, which was ingrained into the three basic laws on criminal side, namely the Indian Penal Code, which in one form or the other maintained that there has to be a mens rea. Mens rea need not be, a guilty mind need not be in the form of knowledge or intention. It may be rashness, negligence, this or that, or fraudulent intention on the part of the person concerned. Therefore, mens rea was insisted upon by the framers of the Indian Penal Code. Under the Indian Evidence Act, this mistrust in the police department was reflected in a number of provisions like sections 24, 25, 26, which enjoined upon the police machinery not to record confessions before the police. Under section 25, confession before a police was made inadmissible. Under section 26, a confession made not before the police, before another person, but while in the custody of the police was made inadmissible. And an exception was made under section 27 that only in those cases wherein some article has been discovered, there is an inherent or a third party assurance that the very fact of finding an article substantiates the claim of the police that this confessional statement or that part of the confessional statement was true. Now that is being also given a go-by by the Supreme Court, as I would be citing one authority. It says that there need not be any finding of any article, even pointing out a place would amount to, would be covered by the provisions of section 27. As far as the Code of Criminal Procedure was concerned, there again certain statutory safeguards were provided in favor of the accused, like section 161 and 162, that a statement recorded under these two sections collectively could not be used for any other purpose except for the purposes of contradiction under section 145 of the Indian Evidence Act. Now, as far as 154 statement was concerned, the first information report, it could not be used against in favor of the prosecution except for by way of corroboration of the complainant, but not for corroboration of any other witness. It could not be used as a substantive piece of evidence. FIR is not a substantive piece of evidence. Therefore, these were the basic ingrained safeguards which were provided under these three basic laws on the criminal side. Now, all that has been given a go by, not only by the different laws which are being introduced, not only amendments which are being introduced, whether it is Criminal Law Amendment Act of 2005 or whether it is Criminal Law Amendment Bill of 2006, but also the certain judgments of the Apex Court during the last 5-10 years. Now, we would make certain references to these judgments, which would show how a slow erosion, not slow, I would not call it slow. Colin did not refer to those judges. We always call it is post-Thomas era. That's the observation of criminal lawyers everywhere. Post-Thomas era, in which K.T. Thomas put the Indian criminal law on its head. And the same work is being taken forward by Justice Arijit Pasayat in the Supreme Court. There is let us not feel shy of mentioning names because we know who are these two judges who have been, and therefore he rightly said, Malimat Committee has observed that only judges who go to the Supreme Court should be really well versed in the criminal law themselves when they were practicing as lawyers. I don't think any more comment is required on that as far as the judges who have made these pronouncements are concerned. Now let us go to certain typical illustrations during the last few years with these gems of wisdom which have come from the Supreme Court. Now the first that I would go to is that there was a lot of there is some method in this madness. Remember, And the bar also has contributed to this. My accusation against the bar is that the so-called top lawyers in the Supreme Court, ultimately Supreme Court says that whatever they decide is the law. And even the obiter dicta of the Supreme Court is binding on the lower courts. And therefore, whatever is the pronouncement of the Supreme Court would come, and there is some helping hand lent by the bar also. Now, as far as the top lawyers are concerned, the so-called top lawyers, they don't appear on the criminal side. There are other avenues like corporate practice. Our young friend was telling me in the morning. Therefore, many of them don't practice on the criminal side. Those so-called top criminal lawyers appear in the Supreme Court only on Mondays and Fridays. You know why? I mean, these are the admission days. These are the harvesting days for these lawyers. And at the end of those 2 days, if you look at them, their faces show satisfaction of a cat which has recently swallowed a rat. Shame. Yeah, shame. They don't want these dirty things of final hearing. Who has time and energy to conduct a final hearing matter? Therefore, topmost lawyers, many of them don't appear in the final hearing matter. As a result of which, mediocre lawyers, who themselves don't know the law, appear before the courts and settle principles of law which have been settled over 3 or 4 decades. Judgments given by a bigger bench are upset by a bench of 2 judges without any reference to the earlier settled law. That is because the lawyers themselves don't know the law, and judges are not supposed to know the law. And when I say this, judges get very angry, but they themselves mention in their judgments, judgment after judgment, that this provision of law was not brought to our notice. What about your own research? What about your own wisdom? But they say that this was not brought to our notice. And therefore, bar has also contributed to this. We find tangent judgments from the Supreme Court, one going this way, the other going another way, without any reference to the earlier cases. This is one. Number 2, it has resulted into the foot of the chancellor type of justice, that any judge before any bench before whom it comes, due to his predilections, the judge decides whether he decides this way or that way. Therefore, bar, as I said, is also a contributory factor to these tangent judgments coming from the Supreme Court. Now, let us go to these illustrations. As you know, as far as the dying declaration was concerned, I will go one by one. I will give you about 15 to 20 illustrations. Some of you may have those copies of those judgments which are being circulated. I don't know. I'm not very sure. You know, there was all typical situation. Earlier, when the person would be brought to a medical officer, he was being treated for injuries suffered by him, he makes a dying declaration. The earlier position of law was that the medical officer who was treating that patient should certify that the patient was conscious at the time of recording of the dying declaration. Then came the law that is not sufficient, but in addition to patient being conscious, the medical officer further should certify that the person was in a position to give a statement, and he was equipped to give that statement. Then came the recent pronouncement of the Supreme Court, which says there is no need of any medical officer certifying that the patient is in a position to give a statement. That means they have dispensed with the requirement of the medical officer's endorsement, which is very unfortunate according to me, because there could be a case where the person was not taken to the hospital, there was hardly any time, and therefore the dying declaration was recorded before the person could reach the hospital. But he has been reached to the hospital and somebody is treating him as the medical officer. And in spite of that, if you don't have the endorsement of the medical officer and it is dispensed with, then it gives a latitude to the police to manipulate statements of persons who may have been dead or half dead or not in a position to give a statement at all, with the help of the relatives of the deceased man or with the help of the interested parties. A wrong dying declaration could be false dying declaration could be recorded. Now, this is that AR 2002 Supreme Court, AR 2002 Supreme Court, page 2973. Therefore, the earlier law has been set aside totally by the by the Supreme Court in this more recent of the judgments. Then the second one, which I was earlier referring to, was that classical illustrations which we knew under Section 27, Discoveries Provision of the Evidence Act. As far as I remember, as a young lawyer years back, we would always cite a case decided by the Supreme Court way back in 1963. That was Prabhu versus State of UP, AR 1963, Supreme Court, page 1113. Now, what had been decided there, they had taken forward Kottayya's case, which was decided earlier by the Privy Council in 1947, that the prior user of that article is not admissible. That I had used this pistol in commission of the offense, not admissible. The ownership of that article, that pistol belongs to me, not admissible. Where did he buy that pistol or that knife? Not admissible. Only those portions of his statement which strictly lead to the discovery are admissible. Therefore, prior use, prior ownership, where he bought it, all these things are inadmissible. And therefore, when you actually discover a thing, it has to be a real discovery in the sense that it is not a natural thing, natural phenomena present there. Now, suppose you go and the accused tells you that I would point out a place where we killed the man. It is an open place. There are no telltale marks, there are no blood marks, there is no troddling of the ground, nothing. There are absolutely no signs. It can't be held to be admissible under Section 27. That is the correct traditional view, because it is an exception to the section